We are breaking down a case. It is at the Supreme Court as we speak. The second oral argument in the case. It's two cases: whole women's health versus Jackson, and then the U.S. government versus the state of Texas. That's what oral argument the court is hearing right now.
You say judges, at least in many circumstances, an enforcer. There are 4 billion tort suits in the United States, okay? And probably in 3 billion of them, somebody thinks something's unconstitutional. All right, so can they all sue the judge? No. Everybody goes into federal court, sues the judge? And in the state court? All right, what's the difference between this case, where you think he's an enforcer, and 4 billion other cases where you've read their briefs? You understand their argument. What's your response to it?
What we have to be clear here is what this case is and what this case is not. This is not a direct challenge on Roe. That is the Dobbs case. That is in a month. But this is a big case because states, as we are representing South Dakota, are taking what I would call unique approaches to how they're handling this issue. Here, Texas did a specific act, and the issue surrounding it right now, Andy, is whether these government, here you got the federal government intervening, that's a question, and then also whether before this case is litigated, and it goes to what Justice Breyer was saying, can you just shut these laws down?
Where is the federal jurisdiction here to get in from the Department of Justice to obtain injunctive or declaratory relief against state court judges, clerks, and other officials to prohibit them from enforcing a law that has been passed by the Texas legislature and is now the law of Texas?
If they grant relief in this case, they open essentially a Pandora's box of additional litigation down the road. Everyone will then run to the federal courts, perhaps run to the Supreme Court and say, no, my rights have not yet been violated, but they will be violated in the future. And I think the Supreme Court is rightly worried about the consequences of any such decision-making.
Justice Breyer, who is not a favorable to the life position, said, if we do this, we really have to do this for everything. It'll apply to all of these tort claims. And then so we're creating a whole new way of suing judges, basically, and joining judges, and the federal government coming in against the state court judge. And so in a way where they're not acting unlawfully, they're just following the law of the state, and whether or not. So again, I think that is key.
All the arguments so far really are more procedural. Does the court have the ability to hear this case? Do they have the jurisdiction to hear a pre-enforcement challenge to a state law? It's not about abortion at this time. Other than the abortion distortion, like you said.
I was going to say, of course, it's always about abortion when the case involves Jordan abortion.
The justices have picked up on that. That's why they're there. That's why there was a week to get briefing done, a Friday order, Wednesday briefs due, and oral argument the next week. I mean, so it's been 10 days. 10 days. No other issue gets this. It's also, remember, unlike the Second Amendment rights, this is not a right that you can actually fight. This is a judicially created constitutional right. It's not legislative created. It's not in the Constitution itself specifically.
A lot of your brief and all the other briefs that have been filed against Texas in both of these cases suggest that we should issue a rule that applies just to this case. But that's inconsistent with the rule of law.
That is a gigantic statement, because he's basically saying what we've been arguing for 35 years, that when it comes to abortion, Cece, really quickly here, all the rules change.
Absolutely. We call it the abortion distortion, and you heard it right there, is that only change the rules for this case, not across the board. And what Justice Alito is saying, well, we can't do that. If we change the rules, it changes them for everybody. But that's not what they're asking. They always want to be singled out and have special treatment.
The fact that these are even being considered, that the justices are having to go through these mental motions and think through all of this, this is because of the new justices on the court.
The new justices on the court, it's states coming up with creative ways to address the abortion issue. As I said, we're representing South Dakota in an informed consent case that I think is very unique and very significant in that regard. But the fact that the court's addressing these issues, I think, is a big deal.